Hi everyone, welcome back to Series 2, Episode 3 of another segment from the Uganda Society for Legal Academics. I am Noe Prisha, and in this topic we are basically discussing business rescue mechanisms post the COVID-19 pandemic. And I'm going to discuss the business rescue mechanism administration. Now the question would be, what is administration? Basically, administration is a business rescue mechanism where a person is appointed as an administrator for a company to help it recover and stay afloat without going insolvent. Now, there's a process. A company can't just wake up and then say we are going into administration. There's a process that a company has to follow. And that process, the first step a company has to take is the company holds a board of directors meeting and then plans on a settlement with its creditors under Section 139, subsection 3 of the Insolvency Act. Now, once they've done that, they've passed the special resolution. Remember, they have to file that special resolution at the company registry. Once they've done that, now they petition court. They can't just move into administration. Now they petition court as a second step. They petition court for an interim protective order under Section 139, subsection 4 of the Insolvency Act. Now, that interim protective order is supposed to protect a company, as the word protective order says. It's supposed to protect a company from any petitions from creditors that may want to liquidate the company. So it's a protective measure that a company takes as it goes into administration. Now, the third step, once it has petitioned court for the interim protective order, in that protective order, there are certain details that are supposed to be entailed in that petition to court for the interim protective order. The things that are not supposed to miss in that interim protective order petition are: you're supposed to include a statement that the company is unlikely to pay its debts, and you must attach evidence of the same. The names and particulars of its shareholders should be one of the details in that petition. Then the third thing, you must show proof that there is a person who has been appointed as the provisional administrator, and proof that they've agreed to actually be provisional administrators. Then you must also include a statement of the company's assets and liabilities. Now, once those things are all included in your interim protective order petition, you go ahead and file the same in court. But the attachments, remember, those things I've just talked about are details that are supposed to be in the petition. Now, there are things you must attach to your petition. One of them is remember the special resolution that the company passed. You should attach it to your petition. Then attach proof of the settlement that you entered into with your creditors. And then you must also show proof that this person that you've appointed as a provisional administrator has accepted to be the provisional administrator for the company. Attach proof of the audited accounts of the company. So basically, once you've drafted your petition and included all those details I first talked about, and then you go ahead and attach those supporting documents, the special resolution, the audited accounts, the proof of the settlement. Now you have your petition and you file it in court. So once the court hears your petition and then allows it, the company is now allowed to go into administration. With the business rescue mechanism administration, it's mainly to help a company recover. But unfortunately, not so many companies have the option of recovery. So if a company is not able to actually recover in its financial distress, then it will have to go into liquidation or winding up. This is another business. It's not a business rescue mechanism, but it's one of the mechanisms to help a company actually fulfill its debt obligations. Not so many companies can actually recover, so administration would not be an option if a company is way too deep in its debts that it cannot actually come out of it. then it will have to go for the option of liquidation. Now, liquidation is like a last resort mechanism. Companies go into liquidation when they have no other alternatives. Their last resort is actually to liquidate the company, sell off all its assets and pay off its obligations, some that they can pay off and some that they cannot pay off. There's no particular definition in the Act or in the Insolvency Act of Uganda that defines liquidation. So basically, in simple terms, liquidation can be defined as a court process where a company petitions court to actually wind up its operations, and once the whole process is done, the company ceases to exist or is no more. There's a process for liquidation. A company can't just wake up and then say we are liquidating, we're selling off our assets. There's a whole process. So now that process, the very first step that a company has to take is to hold a meeting with its board of directors or members of the company, and then decide that, you know what, we can no longer pay our debts, so we are liquidating our company. Now, liquidation has different types. There are different types of liquidation. There's voluntary liquidation, where a company chooses on its own volition, sometimes when it's not insolvent, or sometimes it's insolvent. So it chooses on its own volition to actually apply to court or petition court to liquidate. Now, the second one is liquidation by supervision of courts. I will go into details of the different types as we go on. So it's voluntary liquidation, we have liquidation by court, then we have liquidation by supervision of court. Those are the different types of liquidation. So basically, liquidation has three types under the Insolvency Act. There's voluntary liquidation, liquidation by court, and then liquidation by supervision of court. So as I go into these different types, I'm also going to give the process. Now, for voluntary liquidation, the first step that has to be taken before the process begins is the board of directors meeting. They have to sit as the board of directors, and then they decide that, you know what, we are unable to pay our debts and we are way in too deep to actually recover. So they hold a board of directors meeting, and then they decide that we are going to wind up this company. Once they've done that, after 30 days of the declaration of solvency and registration of the same with the company registrar, the company goes ahead and holds an extraordinary general meeting in which it actually decides with its members and creditors that it is going to liquidate the company. That is provided for under section 268 of the Companies Act. Once it has done that, after they've resolved to actually wind up the company through a special resolution, the company goes ahead after 7 days and files the special resolution with the company's registrar, and a copy is given to the official receiver as provided for under section 269 of the Companies Act. Now, once that has been done, that resolution is supposed to be gazetted after 14 days. It's supposed to be gazetted, and then also a copy is supposed to be put in a newspaper of wide circulation in Uganda. The proposed liquidator goes ahead and calls for a general meeting for all the company's creditors and members, and then that call or notice is supposed to be gazetted and then put in a newspaper of wide circulation 30 days before the general meeting is held. Now once the 30 days go by, now the general meeting is held, and then they agree on how they are going to dispose of the company. The liquidator proposes a plan on how they are going to liquidate the company, and so on and so forth. So after the holding of the general meeting, within 14 days after the meeting was held, the liquidator shall send a copy of account to the registrar of companies, and then also send a return of the general meeting to the registrar of companies. Now, after all that is done, the registrar shall go ahead and register the return of the company, and then the whole liquidation process is supposed to be concluded at that point in time. So in conclusion, that is the whole process for voluntary liquidation. And for the other two types, which is liquidation by court and liquidation by supervision of court, basically the process is not so different, but in liquidation by court, one of the members of the company, whether it's a shareholder, director, or creditor of the company, any of them can actually petition court to liquidate a company. So once court finds out that this company is indeed unable to pay its debts, it can go ahead after the petition has been filed and issue an order that a certain company be liquidated. Now, for liquidation by supervision of court, a company basically petitions court after it has passed its resolution to liquidate the company. It petitions court that it's going to wind up its operations. And with liquidation by supervision of court, the company petitions court that it's going to liquidate, but with that, it's going to be under the supervision of court. So it goes ahead and passes its resolution for liquidation and then files its petition in court, such that the liquidation is supervised with the help of the court. So basically, that is all about liquidation. Those are the three types. And in case there's a company out there that is going into that process or is about to go into that process, that is the process it's supposed to go by. And with that said and done, I conclude my presentation on the different business rescue mechanisms that a company can go with. As I started with, administration being the preventive or recovery method, and liquidation, which was my last discussion, that is a last resort mechanism in which a company ceases to exist. So thank you so much for watching, and you can go ahead and subscribe to our YouTube channel, and you can leave the comments or suggestions in the comment section. We'll be able to answer, and maybe if you have any other topics you want us to discuss, please leave it in our comment section. And thank you.